In today's lecture, we will discuss about the intellectual property rights and its legal framework. Starting with the meaning and the concept of intellectual property right. See, as the word intellect itself denotes the ability to think, the ability to understand, and the ability to reason, a very high level of thought process. So, any kind of creation, any kind of creativity that is created by a mind, it will fall under the intellectual property rights. Unlike physical property, intellectual property applies to the intangible assets and things, like any kind of literary work, artistic work, any logo, any design, any patent design, as well as geographical uniqueness. So any kind of creation out of human mind, it automatically is covered and protected, which is original and unique. The condition is that it should be original and unique. Then it falls under the intellectual property rights. IPR allow to use, to sell, manufacture, reproduce, and even monetize their work. And if someone uses their work, then legal actions can be taken. So overall, what the intellectual property right is doing is that it is encouraging the creator's creativity and it is protecting the original creative work of the creator. Now coming to the importance of intellectual property rights. There are various importance of intellectual property right. First is competitive advantage. See, when a product is registered and have a trademark, then it will definitely builds the goodwill of that product, as it serves the very purpose that it is an original product and it is not a duplicate product. So what it does is that it helps the companies and it will have edge over the other competitors in the market as well, and it will help the company to dominate in the market. The second is revenue generation. See, intellectual property right, on the other hand, it adds revenue to the creator. As intellectual property right can be licensed, it can be sold, and it can be franchised, and with that, it helps the creator to earn and to monetize their work, and that too without selling the ownership. Third is market monopoly. When we talk about patent always apply to any kind of invention that is by the inventor. Before going into public domain, that patented product is used to belong with the inventor for certain fixed period of a time. So what it does is that it will have monopoly over the market. Fourth is protecting against copying. Whenever a product is registered or any idea is being patented, and it falls under the ambit of IPR protection. And from there onwards, no other party can use or exploit your product, your idea, your patented ideas for their own use. And if someone does, then the legal actions can be taken. So again, IPR is discouraging the other from using the inventor or the creator works, for misusing it and for exploiting it. Fifth is consumer trust. As I told earlier, that when there is a registered product and it gets the trademark, then it will definitely have a goodwill attached to it, and it will build the reputation and the trust among the customer and the consumers, which will result in customers' loyalty. Sixth one is encouraging R&D, that is research and development. See, many companies want to expand their business and they want to enter into new market as well. So for that, they want to do some research. They go for research and development. So for that research and development, they need to invest the money into that. And by knowing that their innovation will be protected under the IPR, they are ready to invest. So overall, what IPR is doing is that it is creating a mindset that any kind of invention, any kind of idea will be protected under IPR, which leads to the encouragement of R&D. As we know that Microsoft is the software company which wholly depends on making software and licensing them out and generating the revenue from that. They just earn their revenue by their copyrighted software and the patented software. Now coming to types of intellectual property rights. There are various types of intellectual property rights like patent, trademark, copyright, industrial design, geographical indication, plant variety protection, and layout design of integrated circuit. Coming to the patents. Patent is an exclusive right which is granted for a new invention. Whenever a new invention is there, then it falls under the ambit of patent. Patent ultimately gives the inventor the right to use, to sell, to manufacture, to reproduce, to license, and to commercially exploit the invention. Patent is usually granted for 20 years, and after that expiration of 20 years, it comes into public domain. Thereafter, it can be used by general public. There are certain conditions for getting patents. The first condition is the novelty. It means that the invention should be new and it should be unique and it should not be known to outside world. Second is inventive step. It should have inventive step also. Third is that it should be capable of industrial application. Means that the invention which is getting patent, it can be used in the industry as well. One of the example to it is the COVID vaccine. It has novelty in it, it has an inventive step, and it is applicable and capable of industrial application as well. Now there are certain inventions that are not patentable. Like any kind of traditional knowledge is not patentable. Any kind of medical treatment or method of agriculture are also not patentable. Any kind of invention that is false, that is frivolous, that is also not patentable and cannot be patented. And any kind of discovery of any scientific principle are also not patentable. There was a case regarding to the patent, that is Novartis AG versus Union of India. In this case, Supreme Court denied giving the patent to a drug which prevent cancer just because it was a derivative of a known molecule, preventing patent evergreening. As it was already known molecule, that's why Supreme Court denied that it does not have any kind of innovation or a new invention. So Supreme Court denied on that basis that it is not a new invention. It is already known molecule. So in this case, Supreme Court denied giving patent to drug named Glyvic. Coming to copyright. Copyright is an exclusive right which is given on original artistic, literary work, any kind of dramatic work, musical work, any kind of audio-visual creations, including computer software as well. All these types of work are protected through copyright. Copyright owner, they are usually and generally they are having some rights as well. These rights include the right to reproduce their work, right to publish and to distribute the work, the right to translate the work, and all the right to communicate the work with the public. And at the end, the right to receive royalty. Now coming to the duration of the copyright. See, for the literary artistic work, for musical work as well, copyright belongs for the lifetime with the author. plus 60 years after the death. And for films and recording purpose, that is 60 years from the publication. For example, there are movies which falls under the ambit of copyright. Textbook also falls under the ambit of copyright. OTT series also falls under the ambit of copyright. YouTube video also falls under the ambit of copyright. OTT films and software source codes also falls under the ambit of copyright. There is a very famous case relating to copyright, that is R.G. Anand versus Deluxe Film. In this case, it was held that mere similarity does not amount to violation of copyright. But for copyright violation, there is necessary that something is copied from the original work. The ideas or the expression is copied from the work, then only it will amount to the violation of copyright. Just having similarities of ideas does not amount to infringement of the copyright. Now coming to the trademark. Trademark protects the brand identity of a product. Any kind of logo, symbol, slogan, these all can be registered under trademark. By registering the logo, the product under trademark, it serves and it clearly make a difference and it distinguishes the product of one brand with the another brand. Now, what are the things that can be protected under trademark? Any brand name can be protected under trademark like Tata or Samsung or XYZ. Any logo, any slogan, any signature, even the shape of goods can also be protected under trademark like Coca-Cola bottles. Sounds can also be protected under trademark like Nokia tune. Color combination and the trade dress can also be protected under trademark. With the trademark, the owner gets the exclusive right to use the mark. Owner gets the exclusive right to prevent other from using the similar mark. Talking about duration, the trademark has a duration of 10 years and it can be renewed after every 10 years, which gives the owner the perpetual right. There is a famous case law relating to trademark, that is Yahoo Incorporation versus Akash Arora. In this case, Delhi High Court has recognized domain name as trademark, and in this case it has prevented the defendant from using the same domain name as it is already recognized as trademark and it is with the owner. Coming to industrial design, what industrial design protect? It protects the appearance, not the technical feature of the product, and non-functional visual feature of an article. So what are the articles that are protected under industrial design? Any shape, any configuration, any pattern, ornamentation, all these are protected under industrial design. Examples to industrial design are the perfume bottles which we use, they fall under the ambit of industrial design. The shape of motorcycle also falls under the ambit of industrial design. Your furniture design and your smartphone edge design also falls under the ambit of industrial design and they are protected. Now coming to geographical indication, this type of IPR protects the product which comes from the specific geographical locations. For example, the Darjeeling tea, Banarsi sari, even Hyderabadi halim and the Basmati rice, these all comes under the ambit of GI tag. GI tag is geographical indication. GI tag is a collective right and not an individual right. They possess some unique qualities and the characteristics in their product based on that specific geographical location and due to the origin of that. The duration of GI tag is about 10 years, but it can be renewable indefinitely. GI tag provides fair recognition and the market value to the product. It boosts rural economy, agriculture, and it promotes the cultural heritage as well. Now talking about trade secrets. Trade secret is a type of IPR that protects the confidential business information of the owner, as it has some economic value to it which is unknown to the competitor. Examples of trade secrets are Coca-Cola recipe, KFC seasoning formula, and the Google search algorithm. These all are protected by trade secret. Talking about registration, so no registration is required for this trade secret, but it is protected by confidentiality agreement, by enforcing non-disclosure agreement, restricted access agreement. These all agreements are executed and enforced separately so that the confidential information and the trade secrets are protected from outsiders. Talking about plant variety protection. This type of IPR protects the new plant variety or the breed developed through innovation, biotechnology, and selective breeding. With this, the breeder gets the exclusive right to produce and sell the seeds or plant materials and license for commercial use as well. Plant variety protection is also protected under PPVFR Act 2001, which is unique in itself as it protects the farmer's right as well as the breeder's right. Next is layout design of integrated circuit. This type of IPR protects the original layout design, that is topographies and the semiconductor chips. The purpose of this IPR is to prevent the copying of the complex IC designs and encouraging the innovation in the electronic sector. And the duration of the integrated circuit is about 10 years from the registration. Next, coming to international legal framework. When we talk about intellectual property right protection, intellectual property right gets the protection in the country of their origin. So there was a problem that in case if the business is expanding and if they want to globally protect their intellectual property right, then how this will happen? As intellectual property is territorial in nature and it can only be protected in their own country of origin and not in another country. So to deal with this type of shortcoming, international community developed some convention rules so that the intellectual property rights get protected across the borders globally. These treaties, convention and these organization, they sets the minimum standards and they set the protocol for the protection of intellectual property rights. The international intellectual property rights framework is divided into 3 pillars. First is the global treaties and convention. Second is international organization governing intellectual property rights. Third is cross-border mechanism and dispute settlement system. The first one is Paris Convention for the Protection of Industrial Property 1883. It basically protects the patents, trademark, industrial design and the geographical indications. Key principle of this convention is that it gives the national treatment to the foreign applicants as well in the matter of intellectual property rights. Same treatment is given to the foreign applicants as well as nationals in the member countries. Next is Berne Convention for the Protection of Artistic Work 1886. This convention is related to copyright and it protects the work related to artistic, literary, musical and dramatic works. It also gives the same national treatment to the foreign authors equal to the nationals. Minimum term of the protection is the whole life of the author plus next 50 years. Next is TRIPS agreement, that is trade related aspect of intellectual property rights, 1995. This is a binding agreement which falls under World Trade Organization WTO. This TRIPS agreement applies to all forms of intellectual property, whether it is patents, copyrights, trademark, industrial design, geographical indications, and the integrated circuit as well. It provides as well the minimum standard protection to all the IP across the member countries. It is also imposing criminal penalties for piracy and counterfeiting as well. It has dispute settlement mechanism as well, in which it will impose the trade sanctions on the member countries. Next is WIPO Copyright Treaty, WCT, and WIPO Performance and Phonogram Treaty, WPPT 1996. It focused on internet and digital based copyright protection. It gives protection against the digital piracy on digital platforms, music and video sharing. Next is Madrid Protocol Trademark 1989. This protocol is specifically for trademarks, in which one trademark can be registered in multiple countries by and through single application. Likewise, there is a Patent Corporation Treaty PCT 1970, which governs the patent across all the countries, which deals and protect the patent in multiple countries. And the last is Hague Agreement and the Lisbon Agreement. Hague Agreement protects the industrial design, whereas the Lisbon Agreement protects the geographical indication. Next is coming to international organization relating to intellectual property rights. There are two bodies which administer and overlook all the treaties, conventions, and the agreements which we discussed relating to intellectual property right. The first one is WIPO, that is the World Intellectual Property Organization. It is a specialized United Nations agency also. It administers 26 plus all the IP treaties which we discussed, like Paris Convention, Berne Convention, Madrid Protocol, WCT and PCT. It looks and oversees and administers all these treaties and harmonizes the intellectual property law. And the second body is WTO, that is World Trade Organization, which administers and enforces TRIPS agreement. WTO can also impose trade sanctions in case if there is a failure to protect the intellectual property rights. Other supporting body is World Custom Organization. It helps in detecting the cross-border goods which are counterfeited. Interpol also work against the global IP crimes which are relating to piracy, fake medicines, and luxury goods fraud. Coming to the last, why intellectual property matters. See, every business should have intellectual property and the protection as well of the IP for the survival, for the growth, and for the leadership in the market. In the modern era, the strength of the business depends upon the innovation, branding, technology, and the ideas. So protecting these through IP will give you an edge over all the other companies, outsider, and the people across the world and globe. There are various advantages of having intellectual property right. The first is you have the competitive advantage over your competitors. As I explained, that the logo of Apple cannot be used by any other company. So it will definitely have an edge over other people and other company. And the brand identity of the Apple will alone boost the Apple market. Second is the market monopoly and imitation. As we have discussed that the patent have the right over the invention for 20 years. So the inventor gets these 20 years exclusive right to exploit this without any interference of other people. During this time, no competitor, no outsider can sell or manufacture or use their innovation. The third is that it helps in generating revenue. Without transferring the ownership, just by licensing, franchising, and selling the rights, the owner earns the revenue alone. Just for example, like Disney creates billion just by licensing its character. Next is building brand value and trust. Intellectual property right like trademark, it helps in distinguishing and identifying the goods and services. It helps the customer on relying on the brands with ensuring the quality and the authenticity of that goods. For example, people would like to buy Nike shoes because the brand signifies the trust and performance. Next is it attracts the investors as well as building the partnership. Very often it is seen that small scale businesses or startups, they do not have large kind of or large scale setups, but if they own patented technology, they somehow creates a mindset in the investor that they should invest in their business. Next is encourages innovation and creativity. See, the business engages and invest in research and development only and only when they get to know that their innovation and the ideas will be protected under IPR. So finally IPR motivates in protecting the creator's innovation and various kinds of intellectual property by offering legal protection and the commercial benefits to the creator. Next is it facilitates the global expansion as well. As we discussed that intellectual property is protected globally as well through various convention, treaties and agreement. So basically it is facilitating and protecting the intellectual property globally also, and helping the business to expand globally and preventing unauthorized and counterfeiting. And last is it helps in fighting counterfeiting. We have a live example of a brand named Louis Vuitton, which continuously oversees and enforce its intellectual property right, which prevents from imitating its products. So finally we are at the conclusion, and with this we have completed this lecture and we have discussed the meaning and concept of the intellectual property rights, types of intellectual property rights, and the international frameworks and the bodies which governs the intellectual property rights, and the importance of the intellectual property right. That's all for today, and thank you very much.